leading cause of non-communicable disease such as cancer, cardiovascular disease, diabetes, and chronic obstructive pulmonary disease. Whereas we know that both chronic obstructive pulmonary disease and cancers are related to leading cause from tobacco. I don't think we could say it causes cardiovascular disease, diabetes. I think what we should indicate for those that it contributes to the severity of those conditions, but I don't think that it is a cause.
Okay, so I accept the first point should be adjusted. Remember, I just wondered though, and you're a doctor. Well, you're the kind of doctor who should know these things. I'm a different kind of doctor. But my understanding, maybe layman as it is that lung disease, for example, is diagnosed by doctors at the National Chest Hospital or otherwise from smoking. So would you not say that there
No,
is
no, no,
a...
Chairman. You seem to have missed the point I'm making. I did
Okay,
say
okay,
that we could say that tobacco causes cancer and obstructive pulmonary disease.
right.
As to the other, it causing cardiovascular and diabetes. Now that is
Oh,
where
I
my
see, I see. So you're making a distinction between the diseases. Okay,
yes.
okay, but it can, okay, fine. So it
It's just
amplifies,
that it worsens them. It makes them
yeah,
worse. I
yeah,
mean,
yeah, yeah, okay.
it's
So,
a comorbid or a comorbid factor if
yeah,
one would look at it
no, no,
that
I
way.
accept that. So what I'd ask Mr. Edwards to do, or the team, is just to tidy that up a little bit for me.
Sure.
To say cause and also to make the distinction in terms of making a particular condition worse. Okay, thank you, member. I see Senator Longmore's hand up. Senator Longmore.
Yes, yes, Chair. Thank you. Of course, I have to chime in here. So, I might suggest implicated in the causation and/or severity. So that is basically what the clinical evidence suggests, that it can be implicated in the causation and/or severity. But also at this aspect, I would like for us to add a reflection on the addictiveness of the substance or the addiction component. There's no mention of the mental health impact in terms of a substance use diagnosis and a dependency slash addiction that would come from the use of the substance.
Okay, I like the way you express or captured the expression in a very short, concise way on the first point, and I do agree with the addictive nature. So I'm going to ask
Thank you.
the team to just add that, and we can read it back at the end because we want to try and get this sorted. So can we move on then, since we have no other hand up around those two issues which we accept? Mr. Edwards?
Thank you, Chair. So continuing on that page, it is also noted in respect of contributions made by the tobacco industry to corporate social responsibility activities. Stakeholders had suggested that funds should be channeled through the Chase Fund, but that proposal was stood down on the advice of the Attorney General's chambers because of the amendments that had been made to legislation for different arrangements to be made in relation to the payments to the Chase Fund and the use of the Chase Fund. It is noted on that page also that one of the issues identified by the committee is tobacco use in youth and the increasing demand by youth for electronic cigarettes, e-cigarettes. And then it is noted that there is a prevalence of smoking among male and female students within the 13 to 15 year age group. And we could add the word years of age, instead of just 13 to 15 age.
That's page
Page 4.
4.
Yes, the penultimate paragraph on page 4.
I see Solicitor General's hand up. Do you have one to come in?
Thank you, Chair. Good afternoon to you and members and colleagues. Just a correction in the second paragraph on page 4, that the fund in the penultimate line, penultimate sentence also, the fund should be paid over to the consolidated fund, not to the collector of taxes.
Okay. Thank you.
Thank you.
Noted.
Noted, Chair.
All right. So you had completed your correction, Mr. Edwards, about the years, 13.
Yes.
Okay.
30,
All right.
yes.
So continue. Page 5.
Page 5 now starts the specific recommendations, and it's noted that a number of clauses were not proposed to be amended, and these are stated at the beginning of page 5. We then go into the parts of the bill, part 1 preliminary, and the first change is an editorial one because of the year change that would be necessary. Clause 2 interpretation, there are a number of definitions that the committee was asked to consider and make recommendations in relation to. And I need to indicate, Chair, or remind the committee members that there are still some matters that formal decisions need to be taken by the committee on in relation to definitions, and that's why you will see some of the text is in red. So that first definition of occupational activity is relates to a recommendation that the term that is currently in the bill be amended to mean in relation to a person, means the engagement or employment of the person in work in a commercial or non-commercial undertaking, and whether or not for compensation. So
Okay.
the committee is invited to.
Thank you. So committee members, do we have an issue with this definition around occupational activity? If you do, could you state so now? If not, then we'll assume that we can accept for the report. Okay, I see no objection. Okay, Mr. Edwards, you want to go to the next one, public space?
So the next recommendation is in relation to public space, and the recommendation is that the term should be defined to mean any structure, facility, place of assembly, or other place available to be used collectively by the public, or other place of general resort, admission to which is obtained by payment, or to which the public have access, including a government office and a space or a building of any type, regardless of the ownership.
Thank you. All right, members.
Ms. Birch has a...
Ms. Birch, go ahead. Hold on.
Okay. Good afternoon, Chair and members of the committee. To note that there's a correction. It should be public place and not public space.
Right. Okay. I did say space. So public place. Okay. So that puts it in a little more context. Do members have any comments on that?
Chair,
Yes.
I'm sorry, Chair, I'm not seeing my thing to raise hand. This is Mrs. Seeley Brown.
Yes.
I just wanted to ask Mr. Edwards, because I'm noticing, Mr. Edwards, that some words are inserted, and I'm not sure what is the rationale for that insertion. After the words collectively by the public, or other place of general resort, admission to which is obtained by payment. I'm thinking, wouldn't that be covered, Mr. Edwards, in the general words that are used above? Why are we inserting these words here? I don't have anything in my notes that suggested that these words should have been inserted, so I just wanted the rationale for it. And when we look, Mr. Edwards, at how it's defined in the regulations, It's basically how we had it in the first draft of the list of amendments that were done. And I don't have any note as to this admission that is contemplated or proposed there.
Thank you. Thank you.
Yeah, go ahead.
Sorry, Mrs. Seeley Brown, I just want to be clear, where is is it the issue
Okay,
of admission, the third line of the proposed definition?
Yes, no, the second line where it's after you speak about it being available to be used collectively by the public or other place of general resort, admission to which is obtained by payment. I'm wondering what is, because in my mind, Mr. Edwards, if you speak of any place available to be used collectively by the public, I'm just wondering why that distinction, why are we making that distinction about admission and payment?
Well, part of it is for clarification, because the reference to a place being available to be used collectively by the public may suggest that there is some freedom, license, permission to use, and payment can be seen as a form of control or restriction and access. So it's really just out of an abundance of caution to indicate that even places where you have to pay to access entry should be regarded as public places. That, in other words, the fact that you have to make a payment should not be treated as somehow restricting accessibility by the public. So it's really out of an abundance of caution.
Right, thank you. Thank you, Chair.
Thank you very much. Okay, so let's move on.
Sorry, Chair, I have a question then. If I may?
Yes, go ahead, go ahead.
Thank you. So perhaps the word including admission to which is obtained by payment, because the way it is worded, one interpretation could be that the words admission to which is obtained by payment qualifies the words before. And I don't think it's meant to limit the application of the words before. I think you want to expand the meaning. So I think you would have to make it clear, just as how you did, Mr. Edwards, in explaining the intention. I think that would also need to be clear in the draft, in the formulation, that it includes places to which where you have to pay to get access.
Point taken.
Just to add,
Yeah.
sorry, Chair, just to add, Mr. Edwards, maybe based on what SG is saying, we can place that those words anyway after the word included.
In the
So
latter
when you
part,
include like
exactly.
a government office
Yes.
and rights, it will include a place where you have to pay. So it makes it clearer.
Yes. I accept
Okay.
it. Yes.
Okay.
Thank you.
Thank you, Chair.
Thank you, members, for those contributions. So, Mr. Edwards, you have that then, huh?
I have.
You okay? All right, thank you very much. I appreciate that contribution. So, Mr. Edwards has made that adjustment to read back at the end.
Yes, we will relocate.
Let's move on to
those
relevant.
Relevant product is a definition that had been accepted by the committee, and it's stated as that the definition was amended to include ENDS, the electronic non-nicotine delivery system, and the recommendation is also that the term relevant product be amended to include ENDS. We just want to indicate here how significant this is, because it has implications throughout the legislation. Once you use the term relevant product, automatically ENDS are captured, the electronic non-nicotine delivery system.
Okay. All right.
Secondhand smoke. This is a definition which the committee is invited to consider and confirm if they accept it. Secondhand smoke is recommended to mean smoke or other emission from a lit or heated tobacco product or relevant product in combination with the smoke exhaled by a smoker. So that's the definition for consideration by the committee.
So that would take in the e-cigarettes, right? The e-machines that are used.
Yes,
Okay.
and any vapor, any.
All right. Okay, I see no hand up or anybody commenting, so I'm assuming.
Mr. Chairman,
Yes.
I'm sorry, I too don't see where the hand raise button is on this Zoom platform. Ought that to be, if I could pose this to Mr. Edwards, ought that to be in combination with the smoke exhaled by a smoker, or should the word "or" be inserted there instead of in combination with? Is it the emission from the product as well as the smoke exhaled by a smoker? Aren't both things secondhand smoke? It's not that they're in combination, they're secondhand smoke, but not in combination, they're not. If I'm clear enough.
Yeah, I see the point being made by Senator Golding Campbell. The idea, though, was that in any case where a device is being used, there would be a smoker, there'd be a user of the device. And
yeah, but Mr. Edwards, I can put a cigarette on an ashtray and it emits smoke while it is burning on the ashtray, and I'm not putting it to my mouth to inhale or exhale. And it's still secondhand smoke in that regard, is it not? I'm guided. I wouldn't want us to tie up the definition of secondhand smoke in a way that would make someone say, well, if I'm not exhaling, it's not secondhand smoke if it's coming from my cigarette or my other tobacco product.
I get the point, and I don't think.
Chair, might I just offer a little elucidation here, if I may?
Yes, go ahead.
Yes. So the concept of third-hand smoke, I was wondering whether or not, because that is actually a concept that most persons, most jurisdictions tend to adapt to. I'm not sure if we want to. So third-hand smoke is kind of like what Senator Golden Campbell just described, and or in like a circumstance where, let's say, you're sitting in a chair, or a smoker, the sofa that the person is in becomes very embedded with the smoke, and then someone else sits in that chair that they're affected. I don't know if we are seeking to have that broad coverage to include that concept of third-hand smoke also, or we want to limit it to second-hand smoke, which is where someone is conveying the smoke themselves and that affects somebody directly.
My own view is that if you take it that broadly, it might be maybe difficult.
Yes. Most jurisdictions steer away from third hand because it becomes really very difficult to pinpoint causation.
I think if we can find a way, Mr. Edwards, to add to the wording around exhaled by a smoker, or otherwise, something that
keep it discreet,
in
keep
the
it
presence
separated.
of maybe that's the best approach. So I don't know if you can find a wording, or a member can find a wording to accommodate that. You have a thought on that, Mr. Stein? Go ahead.
Chairman.
Go ahead.
Thank you, Chair.
Sorry, member Guy, and then I'll ask Mr. Stein to come in.
Chairman, I was thinking we recommend that a definition of a term secondhand smoke should be inserted to mean smoke or other emission from a lit or heated tobacco product or relevant product in or in combination, in or combination. So it would take care of the two concerns that Senator Golden has, because one would be that it will be lit and there on the sofa or in the saucer, and or coming from a person who has exhaled.
Mr. Stein?
Actually, so thank you very much, Chair. I think actually Member Guy's comment actually doesn't require my further comments, because I think his suggestion, it addresses the matter at hand.
Okay, so Member Guy's suggestion is being supported on this side. Any further comments on that from the members? No? All right, so can we capture that and reflect that in the final document, Mr. Edwards?
Chair, could I just ask, to be clear, exactly?
Member Guy, you want to repeat that for us, please?
Yes.
Certainly, Chair. I'll read it again. Means smoke or other emission from a lit or heated tobacco product or relevant product. And it says in combination with the smoke from smoke inhaled by a smoker. I was thinking that or relevant product from or in combination and or, sorry. So basically it takes care of the one that where the lit tobacco is not being exhaled, but it is in the environment. And secondly, where it is exhaled by the smoker and it becomes secondhand smoke.
Okay, we understand.
You have that?
Yes, thank
okay,
you.
Great. You want to read it back or you
No, we're going to tidy it up, Chair.
Okay,
yes,
all right.
Thank you.
Okay.
I'm sorry.
Yes.
I just wanted to clarify something again with Mr. Edwards. When I'm looking, because Mr. Edwards, we define words when we want them to mean something that is outside of their ordinary meaning in the way the terms are used or understood, right? And when I look at the way secondhand smoke is defined, generally it covers what Senator Goldenkamp was asking to be incorporated and what Member Guy was asking is suggesting. So why are we even defining it? Because it says secondhand smoke exposure occurs when people breathe in smoke breathed out by people who smoke or from burning tobacco products. And we have already included in our tobacco products the whole ends to mean the electronic nicotine delivery system. So why then are we defining it to mean the same thing that it means given in its ordinary everyday use as understood? I'm a little confused as to why we need to define it then, when we're not taking it outside of what it ordinarily means.
So you're saying...
I'm not sure that...
Go ahead.
I'm not sure that I appreciate Mrs. Celia Brown's comment, but I'm not sure that in the context of legislative prescription that the term second-hand smoke is so specific that we should not define it. I think it warrants a definition, especially because of the sanctions regime around this legislation. I think we have to be very specific what we mean, even though there's an understanding colloquially of what secondhand smoke is.
And I don't think it does any harm to the if anything else, it
guided, sir, guided.
It clarifies. So I think we can accept it. Okay, you want to go to the next?
So the next definition is an amendment to the definition of smoke. And this is because of the expansion of provisions in relation to ends. So the proposal is that the term should be amended to mean smoke means to inhale or exhale or hold or operate, as the case may require, a lit or heated tobacco product or relevant product producing an aerosol vapor or other emission. So this was really to accommodate the electronic non-nicotine devices.
Okay, I see no hand up or anyone commenting on this. So if there's none, then I'll assume that we'll accept that and move on. Go ahead.
Chair,
Yes, who is that? Oh,
Dr. Longmore.
Senator Long.
Yes, thank you. I want to hear before we go further, the clarification regarding the secondhand smoke. I urge that we be very careful of what we finalize, because other jurisdictions are very keen to not include the possibility of third-hand smoke, because I had indicated before, because of the difficulty with relating causation. So if you're seeking to include things like the sulfur, like where the pollutants, third-hand smoke is usually not directly related to the emission of the smoke, but where the pollutants are left lingering in a particular space or entity. If we are keeping it that broad, the consequences of that might result from causation we have to consider. A lot of jurisdictions tend to limit it to secondhand smoke because that is more direct for us to reference causation and linking it to a perpetrator, so to speak.
Right.
So I just want to underscore that we need to be very clear as to what our objective is when we're defining secondhand smoke. Sorry to have to go back, but I just want us to be clear on that.
Right. No, I get that. And
Thank you.
the issue really is how you define secondhand smoke, isn't it? What the contention is. So, and our general consensus around that definition is that it should be an active process that is taking place, meaning a cigarette or other device that is
Yes.
that is giving off emission at a particular point in time, not so much that it is in the couch somewhere,
Yes,
invisibly,
correct.
and so on. So, so what we have to do is ensure that that definition stays, because I do foresee some challenges if we were to do otherwise. So, Mr. Edwards and Ms. Birch, and just find a way to do it that way. All right, point taken. Thank you. So, can we move on now?
So the next definition, Chair, is of tobacco industry, which had been accepted by the committee to mean persons operating as tobacco manufacturers, wholesale.
If the committee has accepted it, we don't need to.
Don't need to read. Oh, okay.
Right. Thank you.
All right. So the next provision. Yes. Chair, the ministry reviewed this definition and wishes to propose in the interest of clarification an amendment to that definition. At the end of the definition, it speaks of persons working to further their agenda. But we felt in the ministry that that wasn't clear. Who is they? Who is there? So the proposal is that it should read persons working to further the agenda of such operators. And that would make it clear what agenda and whose agenda is being referred to.
I mean, I don't know what members think. I mean, I know it's coming from my ministry, so I should be saying okay. But I just wondered whether the legislation is not about a particular agenda, but if it brings clarity, then I'll go with it. Any
Sure, it's actually the original wording we proposed. It's just that the report didn't capture it.
Oh, okay.
Yeah.
All right. Okay. So it shouldn't be contentious then.
Thank you.
Go ahead.
So the next provision considered by the committee is Clause 3, which deals with the objects of the Act. And the significant amendment proposed is in relation to the clause dealing with, the paragraph dealing with information, education, and communication and raising of awareness. That's the only significant amendment proposed in relation to the objects of the legislation. Clause 4 deals with the powers of the minister, and the recommendation proposed that a reference be made to the minister having the power to make provision for the development and implementation of a national strategy for tobacco control that includes provision for the protection of the public and public bodies against any undue influence by the tobacco industry. Clause 41F, this is a recommendation that the words "or advertising" be deleted because of the suggestion that it may appear that one is seeking to address to regulate a prohibited activity, since the advertising of tobacco products is prohibited. So page 7.
Yes, Madam SG.
Thank you. Sorry to go back. The objects clause, the powers of the minister in 4. Sorry, it's not the objects clause, it's the power of the minister to make provision. Where would you be making the provision? It says make provision for the development and implementation of a national strategy. Where would this provision be made?
Okay, it's I understand the SG's point. It's not intended to suggest, it's deliberately broad, meaning that it's not intended to be restricted to making provision in the form of, say, legislation or orders, but it would be provision in the terms of policy and programs, because that is what primarily the minister would be leading. So it is seeking to give an indication of the scope of the areas of policy, one of the areas of policy that the minister or the ministry should be making provision for the development of this national strategy for tobacco control. So that's the intention.
So the reason I raised it, because the rest of the provision talks about prescribe, and we know prescribe means by reg. However, you also have rules of interpretation that say if you have so much of the others saying prescribe, I wouldn't want there to be read into this that you mean legislation, and then when you're doing something, there is some question. I just think it's a little doubtful, and I don't think we want to put something in that's doubtful and that could perhaps even restrict how the minister operates. So I know that this isn't necessarily the actual draft that will go into the bill, right? Is that so? Because if it isn't, then I think you'll have to find a formulation that makes it clear what exactly. I understand you want it to be wide, but you don't want it to be interpreted that it is limiting or restricting the minister to some sort of legislative action. And then when he doesn't do it by legislation, you have a problem.
So can we then just say he shall develop a national strategy and take out, make provision for the development and implementation?
Yes,
and just
because then that doesn't...
Take out the word provision, take out that reference to provision.
And just said, so that you would delete, make provision for the development, and then just say that the minister shall develop a national strategy.
Develop and implement. That's the other thing I wondered. Is the minister...
Well, I don't think we need to say implement either, SG.
And also, I don't know if you want to put that on the minister for him to implement.
Yes.
Either.
Yes.
Meaning you would read into it. No, but I don't think you need to. If it's developed,
I don't think so.
Shouldn't it be?
Developers, I think develop is wide enough, Chair. I don't think we need to say develop and implement.
Mr. Edwards, are you?
I just want to be clear. What is the conclusion?
There's a little confusion there earlier. So can you rephrase that for me, I don't think it's SG who raised it. It's
No,
Mr.
I was just saying you delete, make provision for the development and implementation of, and just say, Chair, the minister shall develop a national strategy, and everything else stays as, will stay as is.
Right, yeah, because the implementation would be up
Okay?
to the technocrats. Okay, Mr.
Yeah.
Edwards, you want to make
yes.
an adjustment?
Accepted. Thank you. Thank you.
Okay, thank you very much. That's noted?
Noted, Chair.
Okay.
So the next provision, we go on page 7, and the next recommendation is that in relation to clause 41F2, I think we don't have the bill in front of us, but this again is dealing with the powers of the minister, and that the provision be amended to speak of prevent or minimize injury or harm to the health of the users or exposure to secondhand smoke. Yes. For clarity, it currently just speaks of prevent injury or harm to the health of the users of tobacco products or relevant products. So this is meant to bring in the whole concept of the consequence of secondhand smoke as a significant source of injury or harm. Mm-hmm.
Okay, SG has her hand up. SG?
Thank you. Just a quick question. I see how the report is formulated, but you will still use the words in the bill talking about use of tobacco products or relevant products, correct?
Yes. Yes.
Okay.
Yes, Chair.
Okay, thank you.
Yeah, proceed.
Yeah.
Edwards, sorry, Chair. Just a question for Mr. Edwards, Chair, if I may. I have in my notes, Chair, that we had made some other amendments to clause 4. So we had put in, rather than 4, clause 4, as it's done here now, where we have 1, clause 1, and it goes up to F, Mr. Edwards. I have in my notes, clause 4 stopped at paragraph B, and then we had inserted a subclause 2 that spoke to notwithstanding the provisions of any other enactment, and that particular clause had paragraph A and B. Is it that my notes are incorrect, Mr. Edwards?
I do not recall that, Chair. I can review our records.
Yeah, because when I look, Mr. Edwards, at what was circulated today, that's what I'm seeing here too. So I'm seeing the 4-1, like similar to what is in my bill, and then I'm seeing the subclause 2, and then the paragraphs are added. So just check it for me, please, Mr. Edwards. It's not to hold up the meeting because it's a drafting issue, but my provision is a little different.
Are you the only one with those notes? Other members?
I don't know, Chair. I don't know. I'm just telling you about the notes that I made, and I check, and I'm seeing something similar.
I hear you, but I'm just saying if you're an outlier, then maybe your notes are incorrect. But I'm asking other members to check to see.
And if you check what was circulated to Chair today, it resembles what I have in my notes. What was circulated today.
I hear you.
Yes. So just check,
Mr. Edwards. Mr. Edwards.
Yes, Chair.
Look to the chair, please. Mr. Edwards, can you proceed, and then we can check back, and then I'll ask other members to do a similar check just in case they have similar notes.
Chair.
No.
Yes.
No.
Can I ask a question? The SG raised a point a while ago and asked Mr. Edwards whether the point, the 41F2, your committee recommends that the provisions be amended with the following words or words to the effect, prevent or that. And Mr. Edwards said that the bill would still reflect what is in the original bill, prevent injury or harm to the health of users of tobacco products or relevant products. Now, my understanding of what Mr. Edwards has in this draft is that that the provision be amended with the following words. It can't be that we're going to have the wording in the original bill, as was suggested by the SG, to be the same as what Mr. Edwards is saying in the draft report. We have to be consistent. So I would like that to be clarified.
The text that is intended, Chair, would be the original text with the words or exposure to secondhand smoke added. So that is, well, what I should say then, Chair, is that the report is in need of correction in relation to that, because our text that we have circulated, which has been largely agreed by the committee, or significantly agreed, is not reflecting that language. So we take the point that the wording really is intended to be the original wording that's in the bill with the addition of the words or exposure to second-hand smoke, so that what is stated in the draft report does not reflect our understanding of the decision in relation to 41F2.
SG has her hand up. SG?
Thank you, Chair. Well, so Mrs. Celia Brown isn't an outlier, because the document that has been circulated by the regarding proposed amendments has the text she's speaking about with 4.1 and 4.2. So, and that was agreed by the committee. So that needs to be reflected in the report. And just to point out that what the draft says is now 4.2F2 has exposure to secondhand smoke at the end, but it also talks about or minimize. So it's prevent or minimize, which is another change to the bill, which my notes indicate was agreed by the committee and is reflected in that draft. It's called Revised Provisional Extract, which has been circulated time and time again, I think prepared by the ministry.
Okay, so this is why I had asked other committee members to check. So,
Yeah.
Mr. Edwards, please note, and team, please note that adjustment. And I'm not sure it's going to be able to be made at the end of this going through here, but just note for me, please, for the corrections.
No,
Thank you.
And excuse me, Chair, just to point out on that, in that same draft, there is an error, because what is now, you have 4.1, 4.2, and then another 4.2. So the latter 4.2 should really be a 4.3, which is now 4.2 in the bill. So that also should be reflected in the report.
Those are my notes to SG.
Okay, thank you. Mr. Edwards, are you guys, you're noting?
I am, Chair, I am.
Okay, you want to proceed then?
So the next provision relates to Clause 6. The next recommendation relates to Clause 6, education and information campaign to be carried out. And the recommendation is that the provision be amended with the words stated. Education and information campaign referred to in Section 5 shall be carried out in all schools and other institutions of learning, and at all workplaces, sports, athletics, and recreational facilities available for the use of the public, and in all communities throughout Jamaica. And that is consistent with the amended text that has been, the suggested text that has been circulated by the ministry. We would just make a correction to start that reference with a capital T, because that is actually the substance of the clause. So it shouldn't be a common T. It should be capital T, the education and information campaign.
Chair, Chair, very sorry to, I know we're trying to speed it to get along, but I'm noticing that we don't have health facilities listed, which is kind of ironic. I don't know if that goes without saying, so to speak, but we don't have any reflection of health facilities.
Well, it does say all workplaces, but it does list a few for emphasis.
Right, that's what I'm saying. Perhaps we should list.
Health of emphasis. Well, we could,
Mm-hmm.
but it would be captured under the all workspaces. You want to list health?
We can do so.
You can, but
Chair.
it's
We can
captured, but
do
okay.
so.
All right, note that. Thank you. Go ahead, Mr. Edwards, clause 7.
So clause 7 deals with the policy of the government in relation to tobacco control. And the recommendation is that clause 7, 1C, 2 and 3 be deleted, and the provisional clause 7.1 A and B be inserted as clause 4.1. So this is where a number of changes were being proposed in relation to the structure of the bill, because there would have to be new definitions inserted. So clause 7 would now become an interpretative provision. One of the challenges, Chair, is that we know that the preparation of the report would have been referring to the original text of the bill largely, and then the recommendations, some of the recommendations have proposed restructuring of the bill. So when we say clause 7, we're speaking of clause 7 as it is now, and it is actually proposed that clause 7 become an interpretation provision for part 3. So we notice that the second sentence under clause 7 speaks to the fact that clause 7 be redrafted to be a definition provision. So it actually won't have that title. It won't have that note of policy of the government in relation to tobacco control. So there are a number of definitions that are proposed. Chair, I don't propose that we need to go through them. They're just listed. So clause 8 speaks to interactions between the tobacco industry, particularly by persons who have responsibility for tobacco control. And the comments in relation to those proposals are stated on page 7. The concerns of the committee in relation to persons who act on behalf of or for the benefit of a public body. So there's a discussion of there's a discussion of the deliberations that took place. I don't propose to restate that. And then page 8 goes on to indicate the scope of the proposed clause 9. I should just state that the committee noted the wide reach of clause 9 in relation to all persons employed by a public body. And the committee considered that public employees might unknowingly invest. And then there was discussion of the levels of staff who should apply to. And then members of the committee were advised of the FCTC guidelines that state that in order to prevent conflicts of interest, there should be clear guidelines for public employees and officials regarding the matter of the potential of interference by the tobacco industry in the public policy. So this page goes on to elaborate the discussion and the contents of the proposals in relation to limitation of interaction between public officers and the tobacco industry. Chair, I don't know if you want your committee to consider any comments.
As I said,
Chair.
Ms. Edwards, unless members have a point to raise, I'm considering it read. So we proceed unless members want to raise a point. Somebody said something earlier?
Yes, Chair, if I may.
Sure.
Mr. Edwards, again, I have in my notes, and I may be incorrect, that a lot of these issues were to be settled, and some of the definitions that were provided are in square brackets, and I remember we had a big discussion, can't remember exactly, but it's in my notes as to why about whether we should use the term specified public official and specified public body, and those weren't defined. Nothing, no definition would have been given for these, and the fact that they're bracketed means that the committee hadn't settled on the policy behind them, and I'm not sure if we're going to discuss that after, or if we're going to deal with them, if the committee is going to deal with it now, Chair.
Chair, yes, but our understanding is that the definition of appropriate authority was in square brackets, but we didn't have any other definitions in square brackets at the end of the deliberations last year. So I don't know if...
I don't know why I had parliamentarian, I'm not sure. Mr. Edwards.
No.
Public official was square
we know
bracketed.
that there was a lot of discussion over several meetings.
Okay, because public
on
official
these
also
matters.
was square bracketed, security forces, and I remember there was a discussion around that, and specified public body in my draft, and specified public official. I don't know if anybody else.
We have security forces out. We don't have security forces in.
So security forces would have been deleted?
Yes, security forces has been deleted. Yes.
Public official. So that looked like that was deleted also.
Yes, our record and understanding.
No, public official is still in the March 18 draft, and it's
right.
Has words in red. A public official in the capacity as such. So, in fact, I'm not really clear on the intention in this draft. So I don't think that was settled.
Okay, well, we didn't actually have those definitions in red.
I think we had referred the discussion to what entailed elsewhere, and looked at some other jurisdictions, and I think we had settled based on what was more the precedent, if you will.
Sorry, I meant the definition of public function. In A, there are words in red for the definition of public function. A public official in the capacity as such. And there were also some words square bracketed in interaction. The words common or business were also square bracketed.
Yes.
So I don't know that those were settled.
Well, those words may not have been settled, but the
right, correct. That's what we're pointing out.
Oh, okay, I thought it was
because they're not. I don't see from the report.
And I remember, I don't know, very vaguely of a discussion around parliamentarians and why it may have been a little problematic to put them here in this category because of the nature of what they do outside of their official duties with respect to conflicts and all of that. Because I have it square bracketed. I
think the parliamentarians put themselves back into the law.
Oh, they wanted to go back in. Okay.
Okay. Yes, I think
so. That's why I don't have it as square bracketed anymore.
Okay.
All right, thanks.
Sorry, can you just route your conversations through the chair? It's getting a little confusing. Mr. Edwards, can you comment on the undecided components that you've just accepted?
Okay, the provisions that are in square brackets.
Because we're not trying to go back and forth again, members. We're trying to settle. So we want to settle now. There's not a discussion that we're going to go back to having again. So just tell me what is the situation there, and let us just agree.
What we have in square brackets is the definition of appropriate authority. It's defined. The proposed definition is that in relation to a public official means the individual or entity that directly or ultimately has oversight of the official conduct of the public official. Yes, this has been proposed for some time. It's still in square brackets for the committee to settle as to whether they
Settle
accept
as in
this
agree
resolution.
with the proposal or not? That's what you're saying?
Yes.
So the matter is before the committee. The proposed wording is there. So if members have a concern, raise it now and let us sort it out. I see Senator Longmore, I think, a hand up.
It is not specifically to just this point, Chair. I'm just looking on at the efficiency of the process that we're engaged in, the very critical nature of the input from Mrs. Seeley Brown and Ms. Aldred and Mr. Edwards, of course. And I'm wondering, because this is now probably about the third or fourth point, where there seems to be some discontinuity in the flow and the level of congruence between the information that is had. I'm just wondering if it might be worthwhile exploring that the three persons, I don't know if it would be helpful to the committee to consider it, or if it is within due process to do so, for them to sit and just perhaps go through the document to ensure that, you know, when we come in this space, that we have the current and most fulsome reflection, so becomes a bit more efficient in the process. Just kind of throwing that out there for us to consider if we can take that approach, please. Thank you.
I think the minutes reflect or should reflect that I have suggested that a few times, both formally and informally. And it occurs apparently once or twice, but each time we get here, there is this, you know, freedom of expression, which I embrace and support at this level to avoid confusion later on. That's why we're here. But I think I do agree with you that we could be a lot more efficient if there was a bit more coordination prior to this meeting. And not this particular meeting, but the process generally. And I've said it to Mr. Edwards, I've said it to my team, and I've even said it to the SG on more than one occasion. So we just have to proceed until we get to the final point, because we need to get this process finalized. But I do recommend it again and again. Yeah. Mr. Edwards, you want to continue, please?
Yes, sure. So we have a script, the issue of appropriate authority. That is a matter for settlement by the committee. And if I may just indicate the context in which the word appropriate authority is used, is when we speak of, before commencing any interaction with the tobacco industry, a specified public official shall state in writing to the appropriate authority within the specified public body that the specified public official is employed or engaged within, that the interaction does not imply an endorsement of tobacco industry practices.
This is a proposal.
Yes, yes, and that's
so the committee can now comment on this for the final report.
Yes.
Is there any?
The issue is the definition of appropriate.
Is there any
authority.
alternative view, or are we agreed on this? Okay, I see no hand up or hear no expression, so can we proceed?
And then the next square bracket is in the definition of interaction, and it speaks to, the interaction is where there's a meeting or any correspondence between a public official and the tobacco industry, or other exchange between a public official and the tobacco industry that arises when the public official meets with the tobacco industry in and then either common or the word business forum. So it's really what word should qualify forum, whether it should be the word common or the word business.
Any any comments on that? SG? Ms. Seeley Brown? No? Okay.
No,
Okay.
no, sir. That will just be a matter for the committee to determine.
Okay. All right. proceed, Mr. Edwards.
So the committee is deciding what, Chair? Because it's 2 words, to choose between 2 words.
Which one were you proposing?
Common, Chair, common forum, meaning that it's not a place that is assigned or designated for either one of the entities. A neutral place, in other words.
Okay. And if there is no objections to that, let's proceed, please.
So the next square bracket in relation to the, okay, there's some words in the definition of public function, and these were inserted for purposes of clarity. So it speaks of a public function, meaning an activity performed a single time or continually, whether or not payment is received therefore, which is carried out by a public official in the capacity as such. And the intention was just to make it clear that we're speaking about a public official when they're operating as such, not when they're at the beach or in their private capacity. So it was really for clarification.
Okay, I recall a conversation around that. Any comments on that? No? Okay. All right,
So Chair, we have no, in relation to the definitions as recorded by the ministry and proposed, we have no further square brackets or highlighted text in relation to those definitions for the proposed clause 7.
Chair, through you, Chair, just to note, Mr. Edwards, I haven't been given definitions for specified public official or specified public body. Those are the only two that's missing for me.
They're in the text, the suggested text of March 18, which was circulated today.
Okay. Okay. Thank you, Chair.
So, Chair, page 8 goes on to just indicate the nature of the deliberations that the committee had in relation to these proposals, and also makes reference to the comparative legislation from Kenya, which influenced the framing of these provisions. Page 9 goes on to speak of the new clause 8, the proposed clause 8, and that's a clause 8 that will now
Hold on 1 second, Mr. Edwards. I see Madam SG's hand up. Go ahead, Madam SG.
Thank you, Chair. Just a suggestion for the report. Since the report refers to these terms, you should be able to look at the report and understand what is being said. So those definitions really should be included in the report, like for specified public officials, specified public body. I think I'm just carrying forward what Mrs. Steelburn had started. I think those definitions really should go into the report.
Okay.
So it's an editorial.
Is that the intention?
I'll take the point, Chair, but we just want to be clear, though, whether if we put it in the body of the report, it's also going to appear in the appendix as the proposed text to be amended, the recommended amendments. So is SG saying we should have it in the body of the report as well as in the appendix, these definitions?
Yes, because it's more easier, it's reader friendly that way. So that somebody shouldn't have to be able to, I'm counting the number of times the terms are used. Somebody shouldn't have to go to an appendix to understand what the terms are. And a lot of times the reports, the appendices are not usually attached to the reports. And remember, the public is supposed to have access, and anybody picking up the report should readily understand. So I'm not saying every single term, but granted, I'm accustomed to seeing a report setting out the major changes, and certainly these definitions and how you're using these terms are major changes. So it's a suggestion
I am,
that they,
I can intervene for efficiency of time to say it's a most appreciated suggestion coming from a lawyer. Um, it's, I agree. Anything to simplify a
thank
report,
you.
anything to simplify a report so that the average John Brown or Mary Jane can understand it, I am all for it. Because I've seen too many of these things where you feel like you're reading a thesis and then people don't bother to read because of that. So I fully endorse that. So members, please, let's try to make it as simple as possible and as easily understood as possible. And that's a good suggestion. All right, proceed for me, please.
All right, sure. There are some textual corrections we are proposing from the ministry to the report. Ms. Burt will outline the corrections.
Go ahead.
So, good afternoon. So for the first bullet point under the heading New Clause 8, the word body should come after specified public. For the second bullet point, in the second line, the word specified should come before public official at the end of the sentence, in line with the text that we have proposed. In relation to the fourth bullet point, the second sentence, we recommend that the regulations that will be developed to cover tobacco control could prescribe instead of could outline. And in the line following that also, record their interactions with the tobacco industry or this form could be prescribed in the tobacco control public health guidance. So we are changing the word, suggesting changing the word outline to prescribe. In the sixth bullet point, the second line, public should come after the word specified, as the term uses specified public body. Thank you.
Okay. Are there any comments on that? If not, we proceed to clause 9, page 10. Mr. Edwards? Your mic.
Yes, so clause 9, the new clause 9 speaks to the avoidance of conflict of interest in relation to certain arrangements or engagements between public officials or public bodies and the tobacco industry. So the report purports to outline the scope of the proposals in relation to the text. So what is stated here is not really a discussion, but really a statement of the content of the proposed clause. We do have a question, though, in relation to a correction in relation to the second sentence under the first bullet point. Ms. Burt will clarify that, Chair.
Okay, so in line with the proposed revised text, the second sentence, should read, we are of the view that the burden of proof should be on the public official to prove that he took all reasonable steps to become aware of his or her holding an interest in the tobacco industry.
So
So the insertion is to delete was not aware, and in line with the text that was proposed, that the person took all reasonable steps to become aware.
Okay. Are there any comments?
Chair, I'm sorry. Can you have her repeat that, please?
Chair, what is happening is that the way the report
Yeah,
is,
but what Member Golding is asking is to repeat
okay,
the line first. Go
Okay.
ahead.
So
Thank
for,
you so much.
so for the first bullet point, the second sentence would now read, or should read, in line with the text proposed. We are of the view that the burden of proof should be on the public official to prove that he took all reasonable steps to become aware of his or her holding an interest in the tobacco industry.
Okay, so I don't think there's an explanation needed, Mr. Edwards, unless it's asked
Thank
for.
you, Chair.
Chairman, you're placing that burden now. Sorry, my
Welcome,
apologies for being late, sir.
welcome, Member Gale. Welcome. Use the hand
Right.
signal to be recognized, but go ahead.
Sorry, Chair. I'm not used to this kind of
Okay,
these proceedings. I'm usually present.
right. Go ahead. What was the point?
I'm just wanting to understand if the burden of proof is resting entirely.
The sentence was incomplete, the question. The burden of proof is resting entirely where?
With the individual, with
Oh,
the public official now, sir.
okay, so Mr. Edwards,
Is that what?
explanation needed, no, Mr. Edwards. Go ahead, hold on 1 second, Member Gale, let Mr. Edwards.
thank you, Chair. So this is why the change was made, because actually the very thing that Member Gale is raising, if we had not made this change, the burden would have been a higher obligation put on the official, because it would have stated that they have to prove that they were not aware of a holding. What the committee had agreed was that there should be a reasonableness in relation to this issue. So this is why we're speaking of that they took steps to become.
Chair, I'm so sorry. Can I just
Reasonable
ask
steps.
Mr. Edwards to put the mic a little closer to him, please, for the benefit of those of us online? He tends to be a little low.
You just need to speak louder, because the mic is literally in his mouth. Mr. Edwards, speak a little louder for me, and then after you respond, I think Madam SG has a comment, but just clarify that point.
That
by
they took
Member
that
Gale.
so the wording proposed is consistent with the deliberations of the committee, that the person took reasonable steps, or they took reasonable steps to become aware of his or her holding of an interest, and not just that they have to prove that they were not aware. So that's a reasonableness that has been introduced, and that was agreed by the committee.
Madam SG.
Oh, so I'm now seeing the degree of flexibility given there now, Mr. Edwards.
Okay. Madam SG?
Thank you, Chair. I am not clear though on, okay, so in the Constitution and in law, it's the evidential burden that can be passed, but the offense itself has to be proved, and you can't pass that to the person. So it's not a matter of reasonableness. It's a different standard. So I am still not very clear what exactly is being said, and I'm wondering if the sentence is needed. I don't know why the sentence is in the report. If you're going to put the sentence in the report about burden of proof, you're going to then have to pad it out and fill it out more. You'd have to then explain what the offense is and what aspect of the burden are you shifting to the, let's just call it the defendant, and what is retained. You need to say more. So I'm asking, do you really have to have this sentence in here? And if you are insisting on it, it needs further explanation. Because the test isn't about reasonableness.
Mr. Edwards?
Yes, thank you, Chair. So we were speaking of reasonableness, not really in the context of a test, but in the context that the proposed wording of the legislation is that this issue of ownership of interest, it should, the test should be the person is to disclose the nature of the interest to the appropriate public body during the course of one's engagement or employment as a public official, as soon as the public official becomes aware of or would reasonably be expected to be aware of the holding of the interest. So the issue may be that this language of burden of proof may not be the most appropriate language to use in the report here. May not be.
Chair,
Member Golding.
I'm so sorry. I really can't find the raise hand speech. I share the concern of the SG, and I'm wondering, subject to her guidance, if what we would want is a clause added to is a provision added to clause 9 that provides a defense for a person who provides a defense for a person who is being accused of an offense under clause 9, that they took all reasonable steps to whatever that language was Mr. Edwards was using just now.
Was that a suggestion? I wasn't clear what.
Not sure if you're hearing me.
You said was you
Raining cats and dogs where I am.
Yes, that was the context. That was the context in which this the whole issue of burden of what is called burden of proof arises. That a defense can be raised once a person shows that they took reasonable steps to become aware of the holding of the interest.
Did you hear the response, Member Golden? And I see SG.
Chair, I'm sorry. I was struggling to hear. Could you repeat it for me, please? I apologize.
He's saying that that is the implications of the wording, which is that person's defense, who is so accused, would have demonstrated some justification or some effort within reason to declare?
To be aware.
To be aware of the interest.
Yes.
And that is, it's worded to give support to to make that a response or a defense to someone who is so accused. Madam AG, you still have a concern?
Thank you, Chair. Yes.
SG,
it's not a reversal. I'm looking at the actual March 18 draft. It's not a reversal of the burden of proof. It's a defense. I think we should just say that.
That's why I said the language of burden of proof in the text of the report is probably not appropriate language. That's,
right.
I agree with
it's really a defense. So you should say that that there will be the public official will be given there's a defense that they can raise. Because the way it's drafted is as a defense. Right. So I don't think we should talk about, because when you use the words burden of proof, it's going to raise some other questions.
I get the point. So, Mr. Edwards, you're agreeing. So you.
No, we had said
we have to reword. We have to reword it
to exclude the reference to burden.
So note that for me, please.
Agreed.
We are slowly justifying another meeting, unfortunately, because of our failure to meet and discuss these issues before. Just to emphasize Member Longmore's point. Go ahead, Mr. Edwards, next.
So in the third bullet point under clause 9, correction, instead of public officer, it should be public official. That's a textual correction. So page 10 goes on to outline the contents of the new clause 10, which is the one that deals with the disclosure of prior or future engagement with the tobacco industry. Chair, I think SG has her hand up.
Okay, SG?
Thanks, Chair. This has nothing to do with whether we met or not. It's just that the committee needs to take some decisions. In the draft, there are some words in square brackets in clause 9. So the committee needs to just take some decisions right here. In 9.4, talks about or any other affiliation. And there's some words in square brackets in 9.4 and 9.9. So that's for the committee to take some decisions, and I would suggest now would be the time.
Well, we have been, I think, so let's continue and decide on what needs to be done now in terms of the new clause 9.
These are the text of words in the March 18 draft text, page 10, subsection 4 of the proposed clause 9. It speaks of or any other affiliation. And let me just read the subsection, it's very short. A person who seeks employment as a public official in a role that involves the developing or implementing of public health policy regarding tobacco control shall declare any current or previous occupational activity, and then the square bracketed words, or any other affiliation with the tobacco industry, whether gainful or not, and then the next set of square brackets, for the purpose of determining whether a conflict of interest exists or is likely to exist in relation to the person. So the words in square brackets are or any other affiliation. So in other words, you're not just declaring occupational activity, you're also declaring any other connection.
We got that. Okay, so if there are no comments, are any comments on that? Okay, no comments, so we proceed.
And then...
Yeah, I'm so sorry. I just want to be clear. What Mr. Edwards just read a while ago was the clause 9, the proposed clause 9.4, yeah?
That's right, Chair.
Yes.
And we're looking at the October 2022 extract.
What?
That's the version of the amendments that I have.
Which document are you using?
March 18.
March
this year,
18.
This year.
Oh, March 18. Oh, I'm sorry. Okay.
Yes,
Of 2023.
2024.
2024. Okay, sorry.
Yes.
Okay.
Okay, thank you. I don't think I have that.
Yes, this is a suggested text that was read in line with the draft report. So it's the latest version. Thank you, Chair. So the next square bracket is in relation to clause 9.9, which appears on page 11 of the March 18 suggested text. And it speaks to a person who contravenes subsection 1, 3, 6, or 7. The question is whether we limit the reference to contravention to subsection 1, 3, 6, or 7, or just speak of this section. Person who contravenes subsection 1, 3, 6, or 7, or a person who contravenes this section is liable to the civil process under section 10A.
Chairman, just Mr. Edwards, Chair. In response to Senator Golding's question a while ago, you indicated that it was the meeting of March 2024. Our last meeting, however, was November 2023. So it has to be March 2023 as opposed to March 2024. We need to make that correction.
No, this is the text that has been developed by the ministry. So it would have to be after the draft report. This is the text to align with the draft report.
Oh, I see. Okay.
But we weren't given a copy of that.
We wouldn't be privy to that.
It should have been circulated. Was it? Huh?
Wasn't circulated, Chair. I don't have it.
I am told it was circulated by the committee clerk. No one has received it? No member of the committee? I see SG's hand up. She can comment, but I'm told it was circulated. But
Chair, I'm looking,
nevertheless,
I'm not seeing any
okay.
such document.
So what we'll do, we'll speak in the mic, please.
It was shared by email prior to the meeting by Mr. Brandon Nash.
I have it, Chair. I have it.
Oh, you have it. Okay.
Yes.
All right. So we'll, for clarity, we'll try and
Excuse me, Chairman.
Yes, go ahead.
Tracy Cohen sent it on November 7. The email came from Tracy Cohen on November 7.
And also, Chair, this morning, Ms. Cohen, correction, circulated the further revised suggested text, which is to be read in line with the report.
All right. So guess what? Let's not detain ourselves on this issue. What Mr. Edwards would need to do, just for clarity, just read the proposed new wording to address those who may not have seen it. So everyone can be on the same
Yes, Chair,
page.
because it would have been sent at 10 o'clock this morning, and I
Yeah,
don't
no,
think
I get
it's
that.
fair to expect us to have reviewed that for a 1 o'clock meeting.
I get that. I get that. All right. So proceed, Mr. Edwards, and act accordingly, please.
So the decision is really in relation to subsection 9, whether the reference should be subsection 1, 3, 6, or 7, or this section.
Any comments? No? Proceed.
Well, a decision has to be made, Chair, because it's alternate language. So,
What are you recommending?
we would recommend the reference to the specific subsections 1, 3, 6, or 7, instead of just saying this section.
Okay. Any comments on that? No? Okay. Proceed, Mr. Edwards.
So on page 11, there is a movement to discuss the deliberations in relation to parts 5 and 6 of the bill. And these are decisions that have been accepted in relation to amendments to the provision in clause 12 to incorporate ends, and amendment to clause 13 to require no smoking signs to be displayed in a manner that is accessible and that enables communication with persons with disabilities. Part 6, the discussion there focused primarily on the issue of protection of children and spoke to the recommendation that the fixed penalty regime be removed in relation to subclause 4 of 15. The thinking there being that there should not be a discounted opportunity in relation to certain offenses against children. And in fact, the committee recommended that graduated penalties specified in the 5th schedule of the bill should be provided for in relation to certain offenses that could affect the welfare of children. Clause 18 relates to the prohibition on public and self-service display, but there was no recommendation for amendment. The report states a discussion that took place. In relation to clause 19, oh, SG has her hand up, Chair.
Go ahead, SG.
Thank you, Chair. Sorry, did the committee decide on the penalty for clause 10A? And I'm not a drafter. I don't have the masters. But I'm just wondering when we have a bill, why are we already putting in a 10 big A? Just throwing that out there for the drafters. But there is a penalty that needed to be agreed, Chair, in 10 big E.
Through you, Chair, what I've done, SG, is when I've incorporated the provisions, I've renumbered. Because we can't have the 10A because it's not an amendment to anything that has been passed already. So we will have to renumber the entire law, the entire bill, and when it's presented.
Just indicate which document you're commenting on. Apparently, the movement between the documents.
The March 18, 2024, Chair, the one that was circulated today. On
Chairman?
page 12 of 29.
Mr. Edwards, are you?
Chairman, if I could just explain, as Mr. Edwards had pointed out earlier, this document will be an appendix to the report, which means it's a part of the report. So the committee has to take these decisions, as the committee has been doing, but it's just that from time to time, if something is skipped, we will be bringing it to attention.
I'm not objecting to those types of interventions. I just want clarity on the document that you're referencing for all our benefits, particularly Mr. Edwards, who has to comment on it one way or the other.
Yes,
So, Mr.
correct,
Edwards.
Chair. And I was just trying to explain why I'm making that intervention. That's all. Thank you.
You're very gracious. Thank you very much. Mr. Edwards, you want to comment on that set of comments?
So the process, Chair, or the?
Based on what has...
Oh, the decisions to be
yes,
made. Oh,
yes,
okay.
yes.
The proposed clause 10A is the enforcement, the proposed enforcement provision in relation to these disclosure and interaction with industry provisions. So the proposed clause 10A is speaking to civil penalties, by the way, not criminal penalties. And the first provision in square brackets is in the, from page 12 to page 13. Let me just read the provision. Subject to the other provisions of this section, if the court is satisfied on an application by an authorized officer that any person has contravened the provisions specified in section 9 or 10, the court may order the person concerned to pay to the Crown a pecuniary penalty not exceeding $1 million. So the committee is not just invited to decide on an amount, but the nature of the enforcement being proposed, the sanction being proposed.
Okay, so should we, I see Member Gale's hand up, but is it that what is there, $1 million is what is being proposed, and members can then comment on?
Well, I would ask a simple question, Chair. How did we arrive at the proposal of the quantum of $1 million? Is it similar to any other kind of legislation? I mean, how did we arrive at $1 million?
Well, first of all, this is the first of this type of penalty being proposed in this legislation, and that's why it's in square brackets.
Right.
It is intended to be sufficiently punitive without being excessive, and it is not separating individual from corporate offenders. So $1 million was just proposed as a figure that would be punitive but not unduly excessive. And remember, it's not a criminal penalty being proposed, a pecuniary penalty.
Okay, anybody else?
And of course, it's a
Can
maximum.
you hear me? I'm so sorry.
Okay, I see
Let me let Mr. Senator Gale go.
SG, and then
Senator Gale, were you finished?
Yeah, I was finished. I was finished.
go ahead,
Um,
Senator Golden, and then SG.
Chair,
Yes.
I'm looking back at the offenses under Section 9, and I find $1 million an excessive penalty, given the offenses we're talking about.
A maximum. It's a
And
maximum.
if there's no distinction between a corporate person and a human person, then I don't know. I find it a little excessive for a public official. I think it can be punitive and deterrent, and be a deterrent without having
But
to
is the
go up to
legislation,
that kind of maximum.
is it, well,
That's excessive.
maximum gives you a range, so it's not, I'm not sure, it would now be subject to the interpretation of the offense and the circumstances around the offense, and I think we should give some leverage to the system of the justice system to determine up to a certain point.
Also,
Very
Chair,
well.
Chair, the provisions applicable don't only apply to public officials. There are some provisions that could apply to an entity in the tobacco industry.
Exactly, and for them, it would certainly not be excessive to go to $1 million. Maybe for others, it may be, so the courts can determine otherwise. So I wouldn't argue too much over it, to be honest with you. My view is that we can.
Very well, Chair. I'm not pushing back on that.
Thank you, appreciate that. SG, you had a point, or that point was addressed? I see your hand down, so I'm assuming you're comfortable.
Yes, it's okay, Chair. Thank you.
Okay, great. Mr. Edwards, continue, please.
Okay, so committee accepts $1 million. Okay. So there are no other square brackets. Chair, what I should also indicate in relation to, yes, what I should also indicate in relation to this provision is that there is a fixed penalty option. So there is basically a option of a ticket type summons arrangement for these offenses. And that's provided at subsection 2 to 4 of this, 2 to 9 of this provision. There is a question for the committee in relation to subsection 3, and that is where the fixed penalty arrangement would kick in, whether the committee would wish us to have a provision that allows for a compliance, a 15-day compliance period, similar to what we have for road traffic ticketing. So how it's worded now, subsection 3, a person shall not be liable to the pecuniary penalty if the fixed penalty is paid in accordance with this section. And then the square bracketed words, and the requirement convened has to the extent possible been complied with before the expiration of the 15 days following the date of the notice referred to in subsection 2, or such longer period as may be specified in the notice. So in other words, you're not just saying that you give the person an opportunity. They have fallen afoul of the provision, whether it's in relation to interaction or as a member of the tobacco industry, making certain approaches to public officials. The question is whether a requirement should be included that the condition on which the fixed penalty kicks in is that whatever contravention or omission had occurred, it has been rectified. So that's the question, whether the committee wants to have that included, that the requirement that has been contravened has been complied with within a period of time.
Any comments? I see Madam SG, go ahead.
Thank you, Chair. Just a question through you to Mr. Edwards. I am aware of that kind of provision in when you have a regulatory framework where there's a licensing regime and so on. I'm not sure it fits here because I can't recall, unless you can point me to it, whether a notice would have been given telling the person that they needed to comply with something. And I can't recall seeing that. I'm not sure it has a place here.
It may not, I agree with SG that it may not apply in most cases, but since we also have provision for offenses that may be committed by an industry player in relation to the giving of gifts or acts of service or contributions in relation to public officials, there may be something that can be rectified. So that's why it is being proposed. But if the committee does not wish to have such a provision, then that's why it's in square brackets for consideration.
Chair, through you. SG, the question that you're asking, wouldn't that be covered by subclause 2 of that same section?
That was a question to SG. SG?
Yeah.
Yes, no, this is the opportunity to discharge, and I'm not even sure. No, it's not the same as, for instance, so through you, Chair, Mr. Edwards spoke about, I think if the committee wants that kind of framework, you will need to put something in at the specific sections where you may have an infringement, and at that point you would also have an inspector or whomever, whichever enforcement officer, giving the person the opportunity to discharge, to rectify the situation by notice in writing. And it's only after that period would have passed that they should be then subject to the enforcement. So I think you need to build in a little more in the bill. So I'm not saying it can't be done, but I don't think it's there right now. So I think it depends on what the committee wants, the framework the committee wants.
Well, the fact that it is being proposed is suggestive of what the intentions are.
Yes. And we can...
And yeah, Mr. Edwards, elaborate, please, because you sounded a little wobbly there on the justification for what is there. So maybe you need to be a little more bullish in terms of why you think it's important.
He sounded here as if he was dependent on the committee itself to make a determination.
The challenge I have is that we have been through the discussions. We're now at the report stage, so there was some justification for putting forward this proposal. So we shouldn't be wobbly about it at this point. So it was just elaborate a little more for me, please.
It is a provision that the committee had not seen before, Chair. So that's why I was being maybe a little reticent, because it's probably new for most committee members, this actual wording. And the concept commented on by the SG. I agree that once the committee agrees that it's useful to have some statement in a notice of whatever contravention or whatever obligation needs to be met, then we can build that into the wording of the provision, and not just say that the requirement has to be complied with, but we can, oblige the authorized officer to specify the nature of the infraction and the time frame which it should be remedied in, which is the general framework of subsection 3 now. So it's just a decision whether we can go ahead and...
So the report has introduced a new concept to which was
not really a new concept here,
discussed before.
It was discussed in the context of having some enforcement provision, but at the time in November last year, the committee didn't have an actual enforcement provision like this, a civil enforcement provision before them.
So you're proposing that it be reworded in accordance with the SG's recommendation?
Yeah, basically elaborating in subsection 3, because subsection 3 does
I hear
provide
you,
a
I hear
framework.
you, I hear you. Is there a view on that? Are we accepting that? SG, you have your hand up again.
Thank you, Chair. 2 points. One, it's actually not in the report, so it would need to go in the report. Two, it's not a matter of just rewording that clause. You would also need to put in a framework wherever you would have had, where you want it to apply. Meaning, in any section where you want to have this kind of notice, this enforcement regime, where you want it to apply, you would need to go into those clauses.
Mr. Edwards?
Noted, Chair.
We have to move, that's a bit more than noted. What are we deciding
I
on?
think there's some drafting issues, Chair, which it may be difficult to settle in the meeting, but there are some drafting issues which, as you have reminded us, in collaboration with the Parliamentary Council and the AG's chambers, we can settle the appropriate language.
So you're going to put an asterisk there for further consultation?
Yes.
All right. I guess we have to. Go ahead.
So,
Chair, can I just say something quickly? I apologize.
Go ahead.
And I don't know if you addressed it. I was having some hearing difficulties. But that same section above the square brackets, where it speaks to how the fixed penalty will be paid. So it's subsection C2. The amount of the fixed penalty and the collector of taxes to whom and the address at which it may be paid. Is that necessary in the act? And I mean, certainly is, people make payments in relation to the collector of taxes online now. So I just wondered why we need that.
Chair, I could respond if you want.
In the interest of clarity and speed, yes, please go ahead.
Thanks. So there is actually the collector of taxes acts under a number of legislation, including, I think, the Tax Collection Act addresses that issue, where if a law speaks of something being to be paid to the collector of taxes, it can be done via electronically, online, and so on. So this is really replicating the language we have in a lot of legislation, but doesn't mean it can't be updated. It's a drafting issue.
Okay. So is it that we're proposing that we try to update the language? Will it have any sort of tangible difference in terms of meaning? I don't want to detain us too much on
we can look at it.
something that's unnecessary, but if it modernizes the language then, and it's not going to take much time, then fine, go ahead and do it. Or make a note, since we are noting a few things that will require further clarification. All right, go ahead, Mr. Edwards.
All right, Chair. The next matter for decision by the committee is actually the amount of the fixed penalty. The subsection 8 proposes that the fixed penalty should be for individuals an amount of 150,000, and for body corporate 250,000, or such other amount as may be prescribed. So this would just be proposing the initial default amounts, which can be amended by prescribed order in future. So the committee is being asked whether these amounts, having regard to the fact that the maximum is $1 million, the fixed penalty is usually a discounted figure, and the proposal is 150,000 for individuals and 250,000 for bodies corporate.
Any comments on this? Are we accepting? Okay, see no objection, Mr. Edwards. So let's
Okay.
accept and
Okay.
proceed.
So having regard to that, Chair, there are no other square brackets in relation to 10A. So we could revert back to page 12 of the report, the draft report. I had just started indicating that clause 19 speaks to the term public places, and it was recognized that there was need to make an amendment, and that was done in clause 2. And then the clause 12, the next provision that is addressed is clause 20, which speaks of the information required on packages, and there was a recommendation that the size be 80%, and these are all matters already agreed on by the committee. Clause 24, part 7, this was a provision that generated a lot of discussion in relation to the retention of the language banning tobacco advertising and promotion. And in the end, the only change that was proposed is to, well, the changes that were proposed are, one, to make provision for ends to be added in relation to subclause 1 of 24, and then in relation to subclause 5, there's a provision that there was an agreement that a proviso be added. And this is a proviso in relation to where you have depictions of tobacco products in media. And the proviso is stated here, essentially that there should be no circumstance in which there is a suggestion that the media insertion or commentary was made for commercial or tobacco industry related reasons. The next provision dealt with is clause 25. This is going into part 8 of the bill, dealing with reports and information, and the committee has recommended that in the annual reporting requirements that any changes made from one reporting period to the next should be reported, such as adjustments to the design features of a particular brand of tobacco product. So that would be an amendment to clause 25. We don't actually have the text of that amendment. We don't. Clause 36, we're now getting to the end of the recommendations, miscellaneous provisions. The main change is the addition of some new clauses. Clause 37, giving the minister the power to issue tobacco control health guidance orders or directions. And then clause 38, the power of the minister to increase monetary penalties and amend schedules by order is proposed to be expanded, which will give the minister the power to amend any provision in any of the schedules. And then we look at the schedules, clause, the first schedule, recommendations in relation to the requirements for. Oh, Chair, there are some square brackets in relation to 37A. Sorry, there are some
Yes,
square brackets in relation
I
to
think it's
37A. Page 23
Yeah.
of the text, the suggested text. And this is paragraph B of subsection 1. So we have 37A B, and this is speaking to the power to make provision for the issuing of guidance, orders, or directions to public officials. B says, well, let me put it in context. So it speaks to giving the minister the power to make these guidance, orders, or directions. And then the scope of these orders or directions may be A, to address the conduct of interactions between public officials or public bodies and the tobacco industry, and such other matters relating to tobacco control as a minister may, and then the question is whether we say as a minister may by order prescribe or as the minister may consider necessary.
Chairman, through you,
Go ahead, member.
could we have a distinction as to how you treat either? In other words, you're giving the power to the minister to prescribe, but considering it necessary would be promoting the same kind of prescription.
Chair,
Yes, member. Member Guy.
the recall that the AG had made some clarification as regards to this in an earlier discussion. Could we therefore ask her to sorry, the SG, to speak on this matter as asked by Senator Gill?
Okay. SG, you want to comment further, or if not, Mr. Edwards can respond to Senator Gale. SG, go ahead.
No, I am so sorry. I missed Senator Gill's intervention.
Yeah, I was asking, the context in which you use prescribed or consider it necessary. Because if you consider it necessary, in my mind, it would be allowing for the same kind of prescription. I just wanted to make a distinction between the two so I can better understand.
Yeah, I'd like to hear Mr. Edwards' view. Sorry, through you, Chair.
Yes, thank you.
SG, this is in relation to 37A.
Yeah, 37A. Yes.
Which is 37A.
37A
1A.
37A 1.
A1A, yes.
B. Yes, I tend to agree with Senator Gale because it could end up being circuitous if we are saying that we're giving the minister the power to make orders or directions to address such other matters relating to tobacco control as the minister may prescribe. The minister does not have to prescribe the context of the orders that the minister is making, but that's what the orders are going to do. So I really believe that the words considered necessary in this context are the more appropriate words, because you're going to end up with a double prescription. The minister is not going to have to address matters that the minister has prescribed. That is my suggestion.
Chair, actually, I'm wondering.
Go ahead.
May I?
Yes, go ahead, please.
Yeah. Couldn't it be aimed at control, just such other matters relating to tobacco control, full stop? You have a lot of words before that,
That can work also. That can work also.
All right, so let's make that work.
So we just delete the words
Yes,
after
please.
tobacco control. Thank you, Chair. Thank you,
Okay,
SG.
and Senator Gale, I'm assuming you're now clearer.
I am now more comfortable, sir.
Great, excellent. Proceed.
So we're
Mr.
in
Edwards.
there's also square brackets in subsection 2 of 37A. The minister shall cause any orders or directions made under this section. I think we can take out the words in square brackets. It says, and all amendments thereto. It's implied that any amendments go through the same making power as the original instrument. So we don't need to say and all amendments thereto.
Chair, through you to Mr. Edwards.
Go ahead.
But isn't that the case, Mr. Edwards, with orders?
Exactly. So we don't need to say and all amendments thereto should also be published in the Gazette. That's what I'm saying.
No, but I'm saying, do we need this provision? Don't we all add orders and directions published in the Gazette anyway? When the minister does an order, it is published in the Gazette.
They don't have, well,
No, they have to be.
the directions, the
yeah.
orders, yes. Orders, yes. And otherwise made available to the public.
Yes.
So it is seeking to go beyond just the Gazette to also oblige wider dissemination to the public.
Are we sure we want to put that?
So if we want to just focus
on the
on
minister?
that we shall cause any orders or directions to be published, to be made available to the public, or to be published in such manner as the minister may direct, something like that, and focus on focus on the publication aspect, the broader publication, as opposed to the Gazette.
Yes, I prefer that. Yes.
Here, I have a little difficulty here. Isn't everything that is published in the Gazette there for the public? So why do we have to have this particular provision?
Chair,
I think SG had provided an explanation, but go ahead, SG, your hand is up.
Thank you, Chair. I agree with Dr. Guy. I don't think you want to put on an additional statutory burden on yourself or the ministry. If you want to go ahead, so the Interpretation Act says that for orders to be legally enforceable, they have to be published in the Gazette. So that's the first thing, why you don't need to say that here. You're placing a statutory burden to talk about make it otherwise made available to the public. I would suggest you do that administratively and not include it in the Act. I do have another point, which is, and I just looked at the Interpretation Act.
Can we just clarify? Can we just agree on this one first, and then you go to the next point? Mr. Edwards, what's your? Are we accepting?
No, we are
recommendation?
fine with
we're accepting that, so we'll make the adjustments.
Accepting that.
Okay, Madam SG, what's the next point?
Right. So just to be clear, that would mean you would delete 2. So
renumber.
2. Right. Right. And then the other point, which I've noticed, you talk about orders or directions. The definition of regulations in the Interpretation Act includes orders and directions. Do you actually have to say orders or directions? Perhaps I'm throwing that out there to both Mr. Edwards and Mrs. Celia Brown. Yeah. I'm not sure. I know that regulations is the overarching term, but is there really a difference between an order and a direction?
Yes, usually
that's why I was saying we stick to orders and agreeing with what you were suggesting, that it doesn't have to even be in the bill, because once it's published in the Gazette, it is made available to the public.
Yes, so although the broad term regulations would cover orders or directions, we deliberately did not want to replicate the regulation making power here. We weren't obliging the minister to make regulations in relation to this matter of guidance. So that's why we use the term orders or directions.
But we taken out that provision, right? So that
No,
there's no need to have a discussion. Aren't we taking it out?
no.
Aren't we deleting subclause 2?
Wait,
No?
wait.
You know, subclause 2
Oh.
just deals with the publication in the Gazette.
Right.
That is redundant. That is redundant to have to say that.
Okay, Chair. So my concern starts from sub 1. So the removal of sub 2 doesn't address the issue I have. But I noticed that in sub 1, it talks about the minister issuing what's called a guidance order. And so now I'm a little confused. I don't know what a guidance order is. And what an order is a guidance order any different from an order?
Well, what we can do is it was meant to qualify what the content of the order is, but maybe we were trying to summarize it too much. So it really should be orders or directions for the guidance of public officials, etc.
Okay, so so it's changing around the words then. Mr. Edwards?
Yes.
Is that acceptable, Madam AG? SG, sorry.
Yes. Thank you. Yes.
Okay. All right, Mr. Edwards, continue.
So there's a square bracket in the, it should be subclause 4, subsection 4 on page 23, which states that until any further provision is made under this section, we just put it in bracket directions because the intention is to have a sample set of provisions for the consideration of the houses to be included in the report of the...
Madam SG.
I apologize, Chair. Back to that same 37 big A. I note that the marginal note talks about codes of conduct, and I think this is now where I realized there was an issue. Codes of conduct are different from orders and even directions. So what is it the minister is to be issuing? Is it codes of conduct? Because then I could understand why some of it is formulated the way it is. So the marginal note says codes of conduct, but the actual text doesn't say so. And there is a difference. So perhaps the committee could decide, is it that you want these I don't know, documents? Do you want them to be legally enforceable or not? Do you want them to be codes of conduct? Do you want them to be orders, which are regulations, which are legally enforceable? I think maybe that's the better approach for the committee to decide how they want to approach these documents, and then it would guide the drafting of the provision.
Mr. Edwards?
The intention, Chair, was for these orders or directions to be treated as codes. Well, the proposal was that they should be treated as codes of conduct. So if we to be consistent in terms of the language of the marginal note and the content of this section, it could state that the minister may issue orders or directions as codes of conduct for the guidance of public officials, etc. I take the point that you want to be consistent in terms of language between the marginal note and the content of the section. But the bigger issue which the SE is raising is whether the committee wishes to have this as enforceable code of conduct. Remember,
Chair. Can you accommodate me?
Yes, please, go ahead, Member Guy.
If we are looking at, and if you look further at B, sorry, A and B of the same 37A, big A, B, A and B, we are also speaking that this interaction between the public officials and the tobacco industry runs the risk of they also be criminally liable. So in that context, I don't think it should just be codes. It should be regulations, you know? That's my thinking.
Mr. Edwards, you.
Um, w- we, we didn't propose to create a criminal sanction in relation to this matter, Chair. We- There's no criminal sanction created. It's to guide the, the operations of public officials and public bodies, but we didn't create any, we weren't, well, the technical team wasn't proposing to make persons liable criminally if they did not follow these, this guidance. And you'll notice that the provision further says that it's not intended to limit the operation of any other provision of law or disciplinary rules. So it's more guidance for conduct and operations in your agency, as opposed to creating infractions that could create criminal liability.
So, Chair,
Go ahead. Go ahead, Member Gale.
are you hearing me?
Yes, I'm hearing you. Go ahead. We're hearing
You're
you.
right. So the code of conduct stipulates, Mr. Edwards, some kind of guidance in terms of behavior. And I'm seeing now where, you know, the question of it being, if it were regulated, then you could have the criminal charges laid. But in terms of enforceable measures now, are you leaving it to the respective agencies?
Mr. Edwards.
The enforcement provisions are primarily those in the proposed sections 8 and 9, which address the interaction between industry and the the specified bodies and specified officials. That's the primary enforcement provision. These provisions are this guidance is intended to address some of the details that had been questioned in earlier meetings as to how will people know, for example, in terms of recording their meetings with industry, those kind of, a lot of administrative details.
I see now. Right. I'm seeing the intent. So it's more operational, administrative.
It's more operational, administrative.
Specific guide.
Exactly.
As to how to behave.
Yes.
How to conduct. How to operate.
Okay. Yes. So if it requires rewording to be clearer, then just consider that, Mr. Edwards. Madam SG, you have a comment? Go ahead.
Thank you, Chair. So, in light of all that is said, I don't think these are regulations. These are either called codes of conduct or guidance notes. So like in the financial world, they talk about guidance notes. Otherwise, you have codes that aren't really regulations. This doesn't sound like it should be regulations. These sound like they really just are codes. So I would suggest if you're making them codes, as they sound like they should be, one other thing then would be how you go about it. I noticed that there's a consultation with the minister responsible for the public service. in all the legislation where we deal with, whether it's guidance notes or codes, which are very administrative, which are very sometimes a little detailed, you also consult the persons who are going to be affected, your stakeholders in the industry, the public officials, and so on. That's usually required as well for that consultation to take place, and then you can have your codes in place. I would strongly recommend that the committee consider going in that direction, making these true codes, not regulations, especially since they're not to be, well, no criminal liability and so on is to attach. And then you widen the scope of the consultation.
Okay.
It's my suggestion.
Point.
Thank you.
Mr. Edwards, what's your feedback on that?
The ministry is consistent, Chair. We didn't intend regulations. So if it needs to be clarified that these are not intended to be regulations, we'll adjust the language accordingly to make it clear that these are our guidance notes, but not regulations. And we were, as Esha had mentioned, the financial industry, that was a kind of approach we were looking at, similar to what directives and those kind of guidance that operate in those sectors. So we are happy with being tasked with just clarifying the nature of these instruments, that there are not regulations, but more in the nature of guidance notes. Is that what I was hearing SG saying, Chair? I just want to be clear.
SG? So hold on. What you're basically saying then is that if it is not in contravention of any sort of,
it's not creating sanctions.
Right.
Yes.
Yeah. Then it could be acceptable even with the objections raised by the SG. I don't know if SG wants to
as long as the language
further reinforce her point if she thinks that there is further justification to be added. You're muted.
I had nothing to add to what I said before. Thanks, Chair.
Thank you. Can we continue, Mr. Edwards?
Okay, Chair, so I think we've finished 37A, and then 38, the square bracket in 38 just relates to the fact that the minister is now being recommended to have the power to amend all the schedules and not just those originally stated in the bill as it is now. So the square bracket around schedules, I expect that the committee will accept the deletion of those square brackets in B.
Unless there's no objection. Anyone? No? So I think we could proceed with that.
So continuing in relation to the schedules, I'm just looking at the second schedule, because everything else in relation to the labeling and health warnings, those recommendations have been agreed. But in relation to the second schedule, in red, the list is to be addressed again when the committee examines the scope of places where smoking is prohibited based on the comments of the Jamaica Psychiatric Association. So the second schedule appears in the lists, the suggested text, to include health facilities, including pharmacies, sport, athletic, and recreational facilities for the use of the public, educational institutions, bus stops, areas designated for use by children. And there's a note that the list is to be addressed again based on comments of the Jamaica Psychiatric Association. So I don't know, Chair, if Senator Longmore should be invited to comment.
Thank you, Chair. I'm trying to recall. I will have to reflect on my notes to see. But I think we had addressed, I think we had
I believe
included, we
so
had made
too. I
recommendations
believe so
for what
too.
we would want to see already.
Yeah, that's my
I don't think we need to make any further
yeah,
adjustments at this time.
yeah.
I'm of that view
That's
too.
my recollection too.
All right,
Yeah,
so
I think so. Yeah, thank you.
is that the final comment?
And then the no other square brackets. Just double checking here to see if okay, there are some square brackets in relation to penalties in these are the fixed penalties in the fifth schedule, Chair. So maybe the committee would
Just
want
go through them quickly for me, please.
to agree. So the first set of square brackets is in relation to conflicting engagements. So this is in relation to the new provisions in Section 9, the new Section 9 dealing with industry issues. And, but hold on. No, Chair, this now has to go in light of the fact that we are not imposing criminal penalties. Then the issue for consideration is that we should now delete these criminal penalties in relation to conflicting engagements between public officials and tobacco industry, because we are providing for criminal penalties, sorry, civil penalties, not criminal penalties. So that's what the committee would have to do, is just confirm that we are taking out any criminalization of those arrangements in clause 9.
Okay, so that is noted, and if there is no objection to that, we proceed on that basis.
Okay. And then in relation to 19.2, this is again in the fifth schedule, the amendments in relation to the fifth schedule appearing on page 26 of the suggested text, selling tobacco products in certain places. 19.2, 19.2, there is a square brackets in relation to the penalty both for individuals and, yeah, just for individuals, whether it should be, I think the committee's concern was that 500,000 may be too high in the case of an individual charged as a first offense. The 19.2 is the one that deals with selling tobacco products in certain places, such as health facilities, near health facilities, educational facilities, etc. And these are places also that they may unduly influence children. So this is the question, whether the first offense level for the individual in relation to the fixed penalty should be 50,000 or 500,000 in the case of a first offense. That's a decision for the committee chair.
Okay, so members, there's a proposal on the table for approval or otherwise amendment. What do you say? Any comments on that? No?
Noting, Chair, that the maximum penalty now, without this fixed penalty regime, is $1 million.
1 minute, yes, we're aware of that. We went through that. All right, I see no comments, so proceed.
So is it 50 or 500,000, Chair, for the first offense?
Chair, through you to Mr. Edwards, if the concerns were in the first instance 500,000 that we consider that too high, then it would be 50. But then if we make that 50, then it would not relate to the next step of offenses.
Yeah, I think 50 is a little low, actually.
Yeah. But I'm just saying here that the next set of offenses would have to relate in terms of the amount, whatever we prescribe for the first offense, albeit a higher threshold for a second offense, then those would have to relate.
All right. Chair, the issue though is that 19.2 currently has a maximum penalty of $1 million. So these proposed penalties don't tally with what is in the law now. The fixed penalty is usually lower. So I think we have to, the committee has to, let us just recommend another range of fixed penalties, Chair.
Right.
That will more align with a $1 million maximum.
Maximum. And also to allow them in steps to be progressive in nature.
Yes.
Can we do that now?
We can do that now. So I'm just double checking what we had in relation to.
Chairman, could I ask Mr. Edwards to speak up a little louder?
I've been trying. Go ahead, Mr. Edwards, speak up a little louder.
I think a shift of the microphone would help.
I don't think it's a microphone. Well, okay. I trust that I can now be heard by all. Okay.
And just make the distinction clearly between the individual and body corporate. Body corporate usually can afford.
Agreed. To you, Chair, to Senator Gill. But there's an issue with this penalty in 19. I'm just trying to confirm.
19.2?
19.2. All right, Chair, what has happened is that in relation to 19.2, there is okay. This is the issue. This is not a fixed penalty. This is a graduated penalty. So, is the committee recommending 50,000 as a first offense penalty, Chair? It's not a fixed penalty. It's just a graduated penalty per individual.
Any comments from the members?
And this is a maximum amount now. So it's not a fixed penalty. It's a maximum. So it will be not exceeding. The ministry is thinking it may be a bit low as a maximum for a first offense. And 100,000 would be more appropriate.
Can we replace 50 with 100?
That's fine with me, Chair.
Agreed.
Okay. Can we do that?
Noted. Yes, yes, Chair. And that is the last set of square brackets we are seeing in that document in relation to...
Chair, sorry, may I?
Go ahead.
So, Mr. Edwards, based on what you just said, you're going to put in not exceeded in all of the provisions. Because the way they're drafted, it's just a fine of 750,000.
We should...
Don't we have to, the way we draft it is not, we would put in not exceeding, isn't it? In all of the provisions. Rather than say a straight fine of 500,000. Not any fixed penalties and any graduated offenses that you just spoke to.
Yes, but we have a general provision that addresses that issue of the maximum penalty. Yes, there's a maximum penalty. Yes, I'll double check that, but we shouldn't have to say not exceeding. But I will double check.
Okay.
We shouldn't have to say that. Yeah.
Thank you.
Thank you.
Continue.
So in relation to the schedules, the amendment in relation to the fifth schedule we just discussed, the recommendation in relation to clause 19, that there should be a set of graduated penalties to address persons who could expose children to sale of tobacco products. That's what 19 is about. And then the sixth schedule, the committee made a recommendation that the reference to clause 15 should be deleted. And clause 15 is in relation to the protection of children, and that's why that's being deleted, because the fixed penalty regime should not apply to those offenses. The new seventh schedule is to be inserted in relation to the tobacco public health control guidance note or guidance. And then the memorandum of objects and reasons, the committee agreed to amend it to refer to the tobacco products and relevant products. And that's the end of the
Thank you.
The text.
Thank you, Mr. Edwards. A very challenging process, which has taken us to not the end, but a few outstanding points. I wondered whether or not, Mr. Edwards, if you could just remind us of the 2 or 3 areas to be sorted out. And I may be venturing here in some territory that's uncharted, but if we were to break for half an hour, do you think we could solve those 2 or 3 issues and then reconvene to complete the report? If members are available for that kind of discussion. Remind us of
I won't be available.
You would not be available? Okay.
No.
Okay. What about other members? Mr. Edwards, remind us of the 2 or 3 areas quickly, please, before the others come in.
Okay, Chair. So we go back to the issue of the rewording of the definitions of public place and secondhand smoke.
That's one.
That's one. And then the issue of the power of the minister in relation to matters of preventing or minimizing injury or harm, just to ensure that the language that is in the report, the draft report, is consistent with the agreement.
Okay, that's 2.
2. And then there is the question of adding a reference to health facilities in the education and information campaign.
That's easy. 3.
Yes. And then there is the matter of the matter of some of the...
There's one other, I think.
Yes, well, there was a discussion on the guidance note and the language that we use in relation to 37A to make it clear that it is, to make it very clear what type of instrument we're talking about.
Right, so that would be 4. Or that would be, 4.
Yes.
Was there any other?
And then in the text of the that has been presented, there is there's a matter of consultation between the legal departments on the issue of the fixed penalty for the interaction restriction provisions, and what notice should be given in terms of compliance, the activities to be remedied, that we would have to have some consultation to ensure that whatever the notice goes, that goes with the fixed penalty
Okay.
clearly states.
So let me propose another an alternative and get members' feedback. If I were to ask as chair that Mr. Edwards, Ms. Birch meets with the SG and the Chief Parliamentary Council Rep, Ms. Seeley Brown, right, and conclude on a recommendation on those 4 or 5 issues, and then circulate that to the rest of the committee members who may or may not sign off, but assuming they sign off on that, then we could just include it in the report and circulate the report for each member to sign, because that would have concluded on the actual report itself. Can we accept that without having to meet back here in this fashion? Is that acceptable by the committee? In other words, everyone will have a comment, and if necessary, we can meet. But I'd like a meeting to take place with the persons who represent the respective organizations that would probably be more important initially, at least, to agree on the draft. Are you
live with that, Chair.
Are you okay with that?
I can live
I
with
don't
that.
have an issue with it, Chair.
Excellent. What about you, Madam SG?
Likewise.
It means that you would have to make yourself available. I know you're a very busy person. Okay. All right. I'm not hearing her, but we can certainly follow up.
Chair, before we go, I just wanted to raise one point with Mr. Edwards. Mr. Edwards, in relation to the 7th schedule, where we are inserting the public health guidance, since this is new to the legislation, shouldn't this also come before the committee for approval if it's going to be inserted as a schedule to the bill?
Yes, but a precedent in terms of the text was not the actual final text, but a document indicating the approach to be taken had been circulated. But of course, the final text that the committee should sign off on should be circulated.
And also, so it would be included in the report as an annex to?
Definitely.
Okay.
This text, maybe when for the benefit of...
Sorry, I was distracted. Go ahead.
No, Chair. CPC, Mrs. Seeley Brown was mentioning the whole issue of the guidance note document, and I said, well, we had circulated a precedent. We hadn't actually circulated the text, the final text, for the committee to recommend. So that should also be included in whatever is circulated, the proposed language of the guidance note.
Guided, Chair.
But I should also mention, Chair, that this suggested text that the Ministry of Health and Wellness has put forward has to be signed off by the other legal departments, particularly the Parliamentary Council.
Which is why I was suggesting.
Yes, because the wording, I mean, the numbering and all that is just for convenience.
Which is why I was suggesting the conversation between those 3 bodies, because the process has been a little, I don't want to say untidy, but it could have been.
So I want to make a suggestion, Chair.
Could have been a little more efficient, put it that way, and I suspect because of the lack of the coordination and pre-meetings which should take place. So given that we are where we are and we are trying to get the process completed, I was going to say within 2 weeks maximum that meeting takes place and the final recommended draft be circulated to members, and this would probably have to be in consultation with the Parliament, right? And then we take it from there. But I'll take your suggestion, Ms. Seeley Brown. Mrs. Seeley Brown.
Normally, Chair, when we are doing the amendments to the text, right, we would do a list of amendments and include them. But because of the fact that the structure of the bill would change because we had to renumber and stuff, would you prefer if I insert, do a draft bill and insert the suggestions in red or yellow so that you guys, you can follow it much clearer than this list of amendments so that you'll have to read side the bill that is currently in Parliament. Would you prefer it that way?
I
That's a
have
better
no,
way, Chair.
I have no issues with that at all. Once it makes the process smoother and avoids us trying to solve some of these technical issues here at this level. I think we've gone through enough and I've ventilated the issues sufficiently to kind of get to that point. So subject to the agreement of Mr. Edwards and Ms. Birch, who will have to lead on my side, I am okay with that, unless other members have other suggestions. Yes,
Chair.
Member Guy.
Having regard to the fact that this bill has been tabled a long time ago and we have gone through a lot of changes, is it possible, CPC, to table a new bill with all the amendments? And what you'll send to us for approval prior to that is the original bill plus the amendments that we have made in red. We agree on it, and then CPC does a brand new bill present to the Parliament as opposed to what was tabled in when was it? Act of 2020.
Yeah, that's what I was suggesting.
Okay.
That was a suggestion, and I agree with it because it would make for a much better appreciation of the final draft and also facilitate a more quality discussion at the level of the Parliament. So yes, I agree with you.
Noted, Chair.
Are we all agreed on that? Yeah? No objections?
Yes, we agree in the usefulness of it, but just that it's not called a bill. It has to be called. Yes, it will be a part of the report. And
Agreed.
The report.
Yeah.
Yes, Mr. Edwards, yes.
Thanks.
I'm being asked a question. Why don't you want to raise it? You have a mic? Okay. You're asking what is it that is being proposed? In terms of the amendments and the report? No. Mr. Edwards, you want to just clarify for
yes,
the minutes?
What I understand, and there's precedent, I recall, for this type of approach where you do basically a mock-up of the future bill, what the bill would look like with all these amendments.
Correct.
But that is still in the context of
a final report.
Yes, and a supplement to the report. But you still, Chair, have to have the detailed changes in the report, whether it's an appendix. It would have to be an appendix. That will be easier. Stating that clause 7 is proposed to be renumbered as X, Y, and Z. You have to go through from section 1 to the end and make those recommended changes. So the document for convenience and for discussion is very helpful, but to reflect the decisions of the committee, every change has to be recorded, and the renumbering that is proposed has to be stated in an appendix to the report.
Okay, so we're back to the
Correct.
original suggestion by Ms. Seeley Brown, and we accept that, okay?
Okay.
Thank
Noted,
you.
Chair.
Thank you very much. And that is captured, of course, under any other business that we will proceed in this fashion. And so the next time, and we're putting some timelines on it. Is that okay? Is 2 weeks sufficient? Ms. Seeley Brown, how much time do you think you need to get this done?
Had started it, but I'm going to have to go over it again and do the necessary mop-up based on the new document that was circulated by Mr. Edwards. But I had started the process already.
Right, so how much time? 2 weeks?
I said 3 weeks. I said 3 weeks.
3 weeks. Oh, I see.
Yes,
okay,
sir.
Fair enough.
Yes, sir.
3 weeks. So that would take us to the end of November. And that, I guess that would be acceptable if at the end of that period we are all on the same page, so to speak. All right, if there are no other comments from members, so in essence, the date of the next meeting would be the circulation of the documents and the signing off of those documents. Is that correct? based on what we have said? Yeah? Once the committee members respond, then we hopefully, based on their agreement, it would represent a signing off of the report itself. Okay, if the protocols are not correct, then we will follow up with members and comment on accordingly. All right, so I won't therefore name a date of the next meeting, but we will be in touch. And I want to use the opportunity now to thank members for their efforts, for their presence, thank the technical team. It's been challenging, but we are here, and this represents progress, which I'm very grateful for. And we look forward to the next phase, and then beyond that, hopefully, if not before the end of the calendar year, early in the next last quarter of the parliamentary year, we would have been able to conclude on this through all the different processes. So thank you very much. Have a great evening, and let's continue the efforts. Appreciate it. Thank you.
Thank you, Chair. Thank you. Thank you all.
Thank you, Chair.
I'm not allowed to speak for myself. They make all the decisions.
I'm not allowed to go anywhere by myself. They're afraid I'll escape.
See how my hand and face bruise up? Them beat me because me say me tired.
I'm only 13, but they said if I work harder, they will allow me to go home.
Me no have no birth paper, no ID. Them take all of my documents, them.
Victims of human trafficking are all around us, and they need our help. Forced labor is one of the many forms of human trafficking. If you see something, say something. Report suspected cases of human trafficking. Call the nearest police station, 119 or 888-PROTECT.
El 5 de junio se celebran dos días cruciales para la sostenibilidad de la pesca: el Día Mundial del Medio Ambiente y el Día Internacional de la Lucha contra la Pesca Ilegal, no declarada y no reglamentada. Esta amenaza la sostenibilidad de los océanos, la biodiversidad marina y los medios de vida costeros, afectando aproximadamente a 22 millones de personas en América Latina y el Caribe. Este tipo de pesca se realiza fuera de los estándares internacionales, socavando los esfuerzos de conservación y de ordenación. La FAO,